We'll call the Collection Service Board meeting to order of May 14th, 2014. Roll call, please.
Yes, sir. Bart Howard,
Here.
Elizabeth Trinkler,
Here.
Elizabeth Dixon, Steve Harb,
Here.
Chip Hellman.
Here.
You have a quorum, sir.
And would you read the notice of meeting, please?
Yes. March 9th. This meeting's date, time, and location have been noticed on the Tennessee Collection Service Board's website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Service Board's website since May 9th, 2014. This meeting was also noticed on tn.gov's public meeting calendar.
We'll review the agenda for today's meeting. And if there are any additions or corrections, Chris, do we need to add this to the agenda, or is that just part of your legal report?
Part of the legal report.
Okay. If there aren't any questions, I'll entertain a motion that we approve the agenda.
So moved.
Moved, seconded, all in favor? Aye. And the minutes of the March 12th, 2014 meeting, has everyone gotten that on the?
We approve.
Motion's been made, we approve the minutes of the March 12th meeting. Is there a second?
A second.
And seconded, all in favor?
Aye.
Sunshine Law.
Yes, sir. We're going to move that to the end. Legal has not arrived.
That's other
The
legal,
other
not
legal,
this
not
legal.
Chris.
That legal,
Not
yeah.
that legal.
Not the real legal. Okay. We'll go ahead then, I guess, with the legal report, Mr. Whitaker.
Thank you, Mr. Chairman. You should have before you the legal report on iPads. There'll be a total of 27 items on the iPads for your consideration. I've also handed out a paper copy of an item number 28 that we received the information needed to make a recommendation for disposition after the draft legal report was already uploaded to the iPads. And as we usually do, we'll have the board take a few minutes to review these items, make notes and questions as applicable on any items you may wish to discuss further. And at the end, we'll vote to approve the report as written or amended as the case may be. And with that, I'll turn it back over to you, Mr. Chairman.
Which tabs is the legal report? Two?
Yeah.
March 14th. Nothing to it. Okay.
Sometimes they're particular.
13. Um, revised financials for the same time period, they showed the other way. Usual that all of a sudden they found more assets.
Mr. Harb, I don't believe they found more assets. I think what they had was, as I've described in here, a math calculation error that led them to not have the right bottom line number. So basically, it's the same numbers that get you down to the bottom line for your assets versus liabilities. I just don't think they added them right.
It appeared to me that when you added them, or when the staff added them correctly, footed them, that they didn't have enough assets and liabilities. So they provided a revised one that now did provide enough assets and liabilities. I guess maybe I read it wrong.
No, actually, kind of the way that works is if there are issues on the financial statement, especially vis-a-vis assets and liabilities, I guess there's a first level of review where you kind of look down the list and check off, okay, and then when you get to the assets and liabilities part, if the math looks right and then there are more assets and liabilities, then you just move on to the next thing. And it could well be that it just happened that those numbers were looked at and said, oh well, more liabilities than assets, and then okay, so we're just going to send it back, and then the company realized, hey, wait, something wrong with this. Oh, okay, stupid human math error. Let's get this fixed and get it back in, and they did. It looked the same to me, but
saying that the balance sheet just didn't balance. It just wasn't added correctly, and once they resubmitted with the correct addition, numbers didn't change other than the totals.
bottom line, yes, sir.
Okay. Word missing, maybe.
Actually, it's a phrase missing, and I noticed that myself. I had 3 ideas to type and got to 2 and never came back to it. Basically, what should be there is just says the respondent did not provide any explanation, reasonable or otherwise, for its failure to timely provide proof of coverage. And, more often than not, if it's a newer agency, they've only been licensed for, maybe less than a renewal period or maybe even 1 renewal period, and they have an issue like that, that's one thing. But, this particular entity has been licensed for actually 10 years and 3 days as of today. And so, and I also think that they previously got a letter of warning for their surety bond coverage not being in on time before. And so when I try to contact them, say, hey, look, I need the coverage certificate, guys, help me out here. They're like, oh, well, we can't do anything, and our legal department doesn't take incoming phone calls. And I'm like, are you kidding? Really? Okay. Ask and you shall receive, so consent order for you.
It's a good solution. Number 26, I just found number 26. There's no license. Because we have no license, we can't find them?
No, it's not that we can't find them. The the allegations were no license plus potential FDCPA violations, not either insufficient or no evidence for the FDCPA violations, but we did get a response from the company, and apparently their chief officer, I don't recall what his title is offhand, but at any rate, I think since we did get a response from the company that they need to know the way we do with pretty much every other out-of-state company. I believe this is in New York. And yeah, this entity's from New York. And, we have a smattering of New York companies that, just get a bunch of accounts from states nationwide, and, sometimes they have licenses for all those states and sometimes not. More often than not, once we tell them, hey, look, cease and desist, and, you guys either get a license and come into Tennessee or don't and don't. Pretty much all those agencies will pick one or the other.
7 was the same kind of thing, and we're hitting them with a $1,000 penalty, which I.
Well, part of, no, actually, number 27 is also an out-of-state entity. It's from a different part of the country. The issue, though, in my mind, on this particular item that differentiates it from number 26 is that this entity offered no written response to the allegations themselves. I mean, you can print out stuff from a computer and send it in all day long, and I must have read that packet of documents 3 times, and I couldn't make heads or tails out of it. I couldn't even guess or speculate as to what the entity was trying to say or why they thought they had a right to collect in Tennessee if they didn't have a license, or even, beyond the very basics. Yeah, okay, there was damage to a rental car, but why does this entity have a right to collect it? I could deduce neither of those things from their so-called response, and if the entity is not going to take even the response seriously enough to try and dispose of the complaint, such that it's not even discernible what they're trying to say, I don't know what else there is to do to get their attention in order other than offer them a consent order and go from there, because unlike number 26 and others where you get immediate responses from people, they're clear that out of state or not, they address the situation at hand, and then when we get back to them and say, hey, look, you guys either got to have a license and work here or don't, and they comply with that, I find that to be a different situation where you receive either no or an unintelligible response.
But these guys are saying they don't need to have a license.
No, they've said nothing of the sort. There was no cover letter, no anything that even purports to explain the packet of documents they sent. It's just a pack of documents that look like car repair invoices, maybe a police report from, stuff like that. And it's just a pack of documents with no explanation that on its best day doesn't and can't answer the allegations, because it's unclear what it means or how this entity is involved in it in any way.
I noticed on number 19, go back to it.
And for everyone who's speaking, just make sure your mics are down closer to you, and that when you're speaking, the red speak light is on so that we can get you recorded.
I just made the comment, I had a question about that one too.
Go ahead, Elizabeth.
Well, just, there may be some other things, but I thought we also needed a cease and desist on that. Is that, if they're not?
That was I was wondering why they did not have a cease and desist, and what are the 3 things that they did to comprise a $1,500 penalty?
Well, the cease and desist language can be included in the provisions of the consent order, so that's not a problem. It's just adding the stock boilerplate paragraph, so that's not an issue. But this particular entity, you'll note mention of the respondent or any agents on its behalf. The other company that this entity was working with to try and service and work on this account appears to be properly licensed in another state, but not in Tennessee. So, I guess if you're looking for the 3 things, you've got this entity who admitted in its written response to engaging in letter writing and telephone campaigns to try and effect payment. Seems like a pretty straightforward admission of unlicensed conduct there. And then beyond that, I mean, I think maybe there's some credit to be given to the fact that they got a licensed entity to work with them on this, but not an entity licensed in the right state. And then beyond that, the some of the documentation submitted by the complainant, it appears, and again, this would all be subject to being proven by admissible evidence at a formal hearing if they didn't want to settle, but it looks like that either this entity and/or the entity that it was working with to try to effect payment may have disclosed some debt-related information to unauthorized third parties who don't even have an arguable reason to know or be told about the debt. I mean, it's one thing if you're attempting to collect from a business, you call up the business and, you know, you've got two partners in the business and maybe you end up talking to the other one because the one who signed on the bottom line originally wasn't available. But, you know, you're calling up business associates of these people, like folks who, for example, are doing business with the company but are not part of the company, to try and figure this out, and then potentially disclosing information related to the debt to those people, that seems to be a little bit of a bridge too far. And again, subject to being proven at a formal hearing, that may well have happened here.
Do you think that we should write a cease and desist letter to the original creditor advising them to cease doing business with an agency that's not licensed?
I think the cease and desist language here could be amended to state that if you're going to retain any other company, collection company, to work on your behalf, you need to understand that they've got to be appropriately licensed in all jurisdictions in which they do business. Because as I understand it, the respondent here is ultimately is 2 or 3 steps down the line, but they have obtained not only an assignment to collect, but I think also title to the debt. I think they may have purchased it as well. And that's fine, but that doesn't relieve them or any entity or agents working on their behalf from the requirements for appropriate licensure.
If they purchase the license, then they don't, if they purchase the debt, then the original creditor doesn't need a cease and desist.
They don't.
Okay, all right, I got you. I noticed that there are a lot of surety bonds that are not being applied on time. Is that because we changed the rule about that, or is there a particular reason that they're not bringing in surety bonds?
No, Mr. Chairman, I think it's just, you know, the statistical, the statistical law of averages. I mean, you've got better than 1,000, maybe 1,500 licensees, something like that. This board meets 5 times a year, and if you got 10 or 12 per report, that's like 60 or so, which is less than 10%. And typically these folks will do it once, they'll get the letter of warning, somebody in compliance or legal will chew on the people that didn't get it in on time a little bit, and then we'll never see them again.
Even so, I would suggest you at least double check the information that is readily available. Make sure the surety bond is emphasized properly. I mean, you can't help but wonder if maybe they're not understanding. It's a lot of surety bond issues. I would think it'd be worth the exercise just to double check and make sure all the things that we have available for agencies to see clearly states that requirement. Maybe bold underline kind of thing might eliminate some of these complaints and reduce your work. Is it?
Go ahead, Elizabeth.
Didn't it occur when we went to the 2-year license, and then a lot of these surety bonds are just for a year, and people just...
Some of it has to do with not running concurrent with their renewal, and they just, I think agencies just
confusing.
forget, oh, I have to do that. These are the result of the staff being proactive and sending certified letters. Their surety bond is not current with us. We maintain that information in our regulatory system. Not respond to our initial inquiry to say, please aware that we do not have a copy of yours on file, please remit that to us. So-
Right.
There were a lot more initially, and this is the ones that didn't respond to your request.
And I think a lot of it, as Ms. Trinkler said, is running
Cycling.
with the cycle of the bond as well as their renewal cycle. They're not always in line.
Are there any other questions with Mr. Whitaker's legal report? If not, I'll entertain a motion. that we-
I move we approve the report amended to include the missing phrase in number 25.
Motion's been made. Is there a second?
Second.
And seconded. All in favor? Aye.
Aye.
Okay. Regulatory flexibility analysis for rules and preliminary board approval.
Yes, sir. Mr. Chairman, this is something, during my tenure as board counsel, we've not yet had occasion to do this because we haven't done any rules, but now that we have some rules working their way through the pre-approval process, one of the things that is required to be done is for the board to review and approve a regulatory flexibility analysis. That is something that I draft. It's required by statute. And I've got to read it into the record at a regularly scheduled duly noticed board meeting, which this is. And then at the conclusion, if no one has any questions, then I will just need a vote to approve so that it can be added to the record such that when these rules do make their way to the rulemaking hearing, that box can be checked off that this was done. So with that, I will read the regulatory flexibility analysis into the record. The Regulatory Flexibility Act at TCA 4-5-401 and subsequent sections requires that prior to initiating the rulemaking process pursuant to TCA sections 45202A3 and 45203A, all agencies shall review all proposed rules and the effect that the proposed rule has on small businesses. The Act requires that each agency shall employ a regulatory flexibility analysis utilizing regulatory methods that accomplish the objectives of applicable statutes while minimizing any adverse impact on small business. The Act further provides that the agency shall consider without limitation certain methods of reducing the impact of the proposed rule on small businesses while remaining consistent with the health, safety, and well-being of the public, and those methods are as follows. The extent to which the rule or rules may overlap, duplicate, or conflict with other federal, state, and local government rules, the clarity, conciseness, and lack of ambiguity in the rule or rules, the establishment of flexible compliance and/or reporting requirements for small businesses, the establishment of friendly schedules or deadlines for compliance and/or reporting requirements for small businesses, the consolidation of simplification of compliance or reporting requirements for small businesses, the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule, and the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. Description of the proposed rules. The board intends to convene a rulemaking hearing at its earliest possible date, subject to pre-approval, in 2014 in order to adopt amendments to the Collection Service Board rules governing the board to remove all references to the location manager requirement, which was removed in its entirety by legislative amendment to the Collection Service Act in 2013. The amendments will also adopt a military applicant rule, which was necessitated by a legislative change in 2013 to provide an expedited licensure process for certain military personnel and/or their spouses. All proposed amendments to Rules 0320-01-.01, -.02, and -.03 will remove all references to the location manager requirement, and the amendment to Rule 0320-01-.01 will adopt the military applicant rule language previously reviewed and approved by the board. Regulatory flexibility analysis. The agency shall consider, but not be limited to, each of the following methods of reducing the impact of the proposed rule on small businesses, remaining consistent with the health, safety, and well-being of the public. Number one, overlap, duplicate, or conflict with other federal, state, and local government rules. There is no overlap, duplication, or conflict with other federal, state, or local government rules. Number two, clarity, conciseness, and lack of ambiguity in the rule or rules. The rules are clear in purpose and intended execution. The implementation of the proposed rule changes will increase clarity and conciseness and decrease ambiguity in the rules as a whole. Item number three, flexible compliance and/or reporting requirements for small businesses. These rules do not create any new reporting requirements for small businesses. Item number four, friendly schedules or deadlines for compliance and/or reporting requirements. The proposed military applicant rule will expedite the licensure process for certain military personnel and/or their spouses. Otherwise, these rules set out no new compliance or reporting requirements. Number five, consolidation or simplification of compliance or reporting requirements. Again, there are no new compliance or reporting requirements as a result of this amendment. Number six, performance standards for small businesses. These rules do not set out operational or design standards. As such, there are no performance standards for small businesses as a result of this amendment. And finally, item number seven, barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. It does not appear that these amendments will erect barriers or have other effects to stifle entrepreneurial activity, curb innovation, or increase costs. If there are any questions regarding this analysis, I'm happy to entertain them at this time. Otherwise, Mr. Chairman, I will need a vote to approve this analysis as part of the rulemaking hearing process.
Only one question that I have, when you mention the military, does that mean that if someone's just recently gotten out of the military, they can come and have a license without any prerequisite training or knowledge in the business?
Well, in all candor, Mr. Chairman, the likely applicability of this amendment to this board is somewhere approaching nil, because now that the location manager requirement has been removed, they're collection agencies, not so much individuals. However, all regulatory programs were required by this statute change to implement this kind of rule, so that's what we're doing. But with that said, to your point, I don't think that anyone in this board or any other board would be allowed to just get a license with no training or that they're otherwise not qualified to obtain. I believe the purpose of this is more to make it such that someone who, for example, is, they have a renewal coming up, let's say in 2015, but they are going to be deployed to the Middle East this summer. Well, this would allow them to go ahead and expedite that process for renewal, get themselves renewed as necessary, and then so that they can go do their military duty without worrying about that. And then on the back end, if they've been deployed and their license has gone past due or whatnot, this will create an expedited process for them to come back in and get renewed and relicensed and everything else. But it doesn't allow them to skip out on any of the requirements that would be mandated for renewal depending on the kind of license it is. It just makes it so that each board and regulatory program has a process in place to say, okay, we understand that there are going to be folks who fall into this category. They've been serving our country, and so the legislature says let's try and help them get back in and reintegrate into civilian life as best we can.
Qualify for an expedited license? I mean, it says military. I find that.
No, sir.
It's-
To answer your question, you would not. It's
And I don't need one.
It's for folks who are currently in the military, and the only reason, as I understand it, for which this expedited licensure process would or could apply is for folks who are either departing to or returning from active duty deployment And it's, you know, definitely for this program, it's a real small number, but even for other programs, it's, you know, it's not that high a number, but because it, you know, it's kind of a legislative priority, wanting to help veterans and things like that, that got passed, and so now we have to do what we need to do to affect that rule.
Been made that we accept the rules. Is there a second?
Second.
And seconded, all in favor?
Aye.
Okay. Discussion of attorney exemption under the Tennessee Collection Service Act.
Mr. Chairman, you and I had spoken about this previously. I'll do a brief summary and then turn it over to you for discussion. And I guess in the course of the last few months discussing the attorney exemption, the Tennessee Collection Service Act, Chairman Howard wondered if that was something that could and or should be, I guess, clarified by rule to make it where only Tennessee licensed attorneys would be able to avail themselves of that exemption. That, you know, that is something that obviously would have to, as all other rules, pass legal review and legal muster. After discussing it with my direct supervisor, you know, we are unclear as to whether it would or not. I mean, we just don't know. That would be up to the AG's office, because it would purport, I think, to narrow the scope of a broader statutory provision, and in some of those cases, the AG's office will come back and say, no, you know, you can't do that. I don't know if that would be the case here, and certainly the board can and should have whatever discussion it wishes on this matter. And if the board's decision is, hey, let's try and incorporate this into a rule, we will undertake the process, do what needs to be done, and the AG's office will say yay or nay. The other potential option is to hold off on a rulemaking hearing and ask for an attorney general's opinion up front. There is a process. It's much simpler and less involved than a rulemaking hearing, as you're remembering and finding out with the rules we have now. Basically, a letter would be drafted just saying, this is what the statute says, here's the attorney exemption, and then pose the question directly, does the board have the authority to limit this exemption to only Tennessee licensed attorneys? Once received, the AG's office will do an analysis and review and send back a written opinion to the board. Sometimes that gets turned around quick, 60 days. Sometimes I've seen it take several months. But in any case, it's still quicker than a rulemaking hearing. And the upside to that path would be, if the AG's office comes and says, yes, the board can do this, then the likelihood that it would come back on the back end for the post-rulemaking hearing legal review before the rule goes into effect and say, no, you can't do this, is almost zero. So those are the two paths before the board if it wishes to move forward in any way after discussion. But I did want to put that out there before y'all got going, and with that, I'll turn it over to Chairman Howard.
This came up, I called Chris as a question, because I had some solicitation coming from an attorney in Maryland wanting to do collection work for me. And he's in Maryland. And my first question was, well, are you licensed in Tennessee? And he said, no, I'm a licensed lawyer, not licensed to practice law in Tennessee, but I am a lawyer in Maryland and practice Maryland, I think, in another state or two, but not in Tennessee. And then it began the question. I began to question whether the statute, the way it's written, would prohibit a lawyer from some other where, even if they're a lawyer in any other state, to come in here, do collection work and what have you, without any kind of state licensure. So I asked Chris about it, and that's where we were. And I don't know what the the board has any discussion about it, or
Is what you're quoting in these rules that we have? What, yeah, I'm sorry. What rule is it that you're referring to where it says that you refer
attorneys are exempt.
professional
They're
license?
they're just exempt under
Yeah.
the law, there's no rule.
Yeah, there's not a rule in
Is there
here.
anything in our, it sounded like you're quoting some of our rules or laws that deal with it, but
That would be TCA 6220-103. I'll get you a subsection here in just a moment, but
Exemptions, this chapter does not apply to
A2
attorneys
says
at law.
attorneys at law, and that's all it says. Subject to a very few narrow exceptions. You're not supposed to. I mean, you're generally supposed to be licensed by reciprocity. I mean, you can do it by motion if you've been practicing long enough. That varies state to state, but
reciprocity in Tennessee, then they could probably collect in Tennessee.
they got reciprocity to practice law in Tennessee, they could practice law in Tennessee. It is, I guess, a little less clear, and arguably the reason that Chairman Howard has brought this up as to whether they could collect in Tennessee. The plain language of the statute suggests that they probably could, absent a rule or maybe even a statutory amendment to the contrary. But that's, I think that's why we're having this discussion.
Great question.
I do too.
The way you phrased it, honestly, this we're a licensing board, attorneys are licensed, their theoretical level of license is higher than our licenses to do legal matters in the state, but you have to do legal matters in the state, as you just pointed about reciprocity. The way it's written would almost preclude anyone who's not a licensed attorney in the state. It kind of, to me, presumes that. So,
And that's a fair point, and I think where the water gets muddied a little bit, could be a distinction without a difference, but arguably there is legal work and there is collection work, but with an attorney who does collection work, seems to be that it would be a ton of overlap, or maybe even in some cases 100% overlap, and I'm not so sure how you separate the two. For an attorney to say, okay, for example, Chairman Howard's scenario, I'm licensed in Maryland and I'm going to avail myself of the attorney exemption to collect in Tennessee, but I'm not going to do legal work to do so.
Letters, and I'm gonna make phone calls, and I'm gonna do everything.
And I'm going to do
else.
it on my
Like-
law firm letterhead for Maryland
Yeah,
or whatever.
yeah. I don't think I necessarily agree with that line of thought, because there are collection law firms, and they've got call centers just like collection agencies do, and the calls come from the law firm, and they're very aggressive about it. Rarely does it end up in a legal in a suit being filed. Rarely.
when it does, they forward the suit to a Tennessee attorney.
Yeah, that's right.
And so that would almost define that they really shouldn't be calling in the state, because they're not licensed to call in the state if they forward the suit.
So to kind of flesh out your line of thinking, Mr. Arbin, tell me if I'm incorrect about this, but if your thought process is that an out-of-state attorney, absent licensure by motion, reciprocity, or even pro hoc vice, to allow them to participate on a single matter or a few matters on a case-by-case basis, if they do not somehow qualify for licensure to practice law in Tennessee, such that they could not file a collection lawsuit in Tennessee if it came to that on the underlying debt, how then could they purport to do collection work. Does that
That's pretty much it.
properly phrase your question?
If they have gone to the trouble to be legally licensed in Tennessee to practice law in Tennessee, then they should be under the exemption. Tennessee license or Tennessee reciprocity. The other thing you mentioned, which it allows single or minimal cases, you said ad vitam.
It's a Latin term. It's called motion by pro hoc vice. That is typically done where there is already a lawsuit being filed or it's contemplating being filed. The short version of how that works is, Mr. or Miss out-of-state lawyer X files paperwork with the Tennessee Board of Professional Responsibility, which is under the Supreme Court of Tennessee, and tells them that, this matter is going to be heard in a Tennessee court, and most of the time, it either requires or they just choose to do it. They have Tennessee licensed co-counsel to assist them in the matter, and then they pay the fee, do the paperwork, whatever else has to happen, and then in return, the BPR will say, okay, your motion to practice in Tennessee pro hoc vice for this one or few matters only is granted, but this is all you may do. Based on this grant of your motion, you may not generally just go start practicing willy-nilly in Tennessee.
That would be a situation where I don't think they can make calls into the state unless they got that for each call because they're practicing.
Yeah, well, that's basically what this lawyer wanted to do. He wanted to, a debtor gets, then at least we have to consider the least sophisticated debtor rule. A debtor gets a letter from a lawyer. It doesn't matter where the lawyer's from, but it says attorney at law. He's going to pay more, that's going to have more force and effect upon that debtor paying that bill than it had come from ABC Collection Service. I think, and I don't, and that guy solicited me, and I said, well, are you a licensed agency in Tennessee? And he said, no, I'm a licensed lawyer in Maryland, and I think he said Massachusetts too. So I don't have to have a license. And that's when I looked it up, and sure enough, it says attorneys at law. It doesn't say that they have to be licensed in Tennessee. And if they're licensed in Maryland, can they practice, can they do collection law? Can they do collection work in Tennessee? I don't think so, but I think it's worth a question for the AG, at least.
Agree. I agree. That's the route I would go, is get the AG opinion first.
And what I will need is a vote to approve that, and then also to give Chairman Howard the authority to work with me, because the board's next scheduled meeting, if I'm reading the calendar, there is one in July? Oh, never mind. Okay. Well, there is a meeting in July. I apologize, but if you would like Chairman Howard and I to work on this in the interim to try and get this going sooner than the next board meeting, to also authorize him to do that so that we can communicate back and forth in whatever form that letter ultimately takes, as long as it falls in line with what the board has discussed here today, that we can go ahead and get that sent out before then.
So do we need just one motion or two motions?
Just one motion.
One motion authorizing you and I to work together to communicate with the AG about this issue.
Well, yes, the letter would be sent from me on the board's behalf. It would bear your signature, and but we would get the work done on the text of the letter before it goes anywhere.
Make a motion that you send a request for an opinion to the AG on this matter in between meetings with Chairman.
Motion's been made. Is there a second?
I second that motion.
Is there any discussion about that motion? All in favor say aye.
Aye.
I know that I can't talk to Bart about this, but I can talk to you about it. When
Yes.
you guys finish the letter, can I just read it real fast before you send it off? Because I was listening to how you'd word it. Do you mind shooting it to me by email before you send it off?
I could do it individually, provided that, as you mentioned, you don't speak to any other board members
Okay.
about it or anything else.
No.
We could probably do that.
That's the reason I asked you guys finish it up, just shoot it over, and I'd like to glance at it, because the way, your original description of how you were going to word it, I was curious about how you'll come at it.
Not a problem.
Chairman, could I request a
Yes, ma'am.
break for a few
You
moments?
certainly can. yes.
Actually, I was also gonna ask that, legal has arrived, so we'll get set up for the sunshine presentation, so you'll have that immediately following, if that's all
Okay.
right with everyone?
10 minutes.
Yeah, I usually do anyway.
Okay, we will reconvene the Collection Service Board of March the 14th, or May the 14th, 2014. And would recognize the Sunshine Law presentation by,
Eamon Romano, Mr. Chairman and members of the commission, thank you for having me before you this morning. I am sorry about the confusion. I have to fall on my sword for you a little bit. This last weekend was super busy for me. My first daughter was born and we had her baptized on Friday. Saturday morning I graduated from law school. Sunday was Mother's Day. Instead of just having one mom, I now had three that I had to take care of, and then came to work Monday morning.
try to
So-
stay busy, okay?
Yeah, so I appreciate your patience as we get going a little bit late here this morning. I'll be talking to you today about the sunshine laws. In Tennessee, we say sunshine law broadly. We're really talking about two laws. And by the way, if you have any questions as we go on, just stop and ask me, and I'll be happy to answer them as best I can. Excuse me. We're talking about the Open Records Act, and we're also talking about the Public Meetings Act. The Open Records Act, I'm not going to spend a whole lot of time on as a matter of course on a day-to-day basis. That's something that your executive director, Ms. Whaley, and her capable staff will deal with. I'm just going to give you a little bit of a window onto that so you have some idea of what's going on. We'll spend most of our time this morning on the Public Meetings Act. I expect that y'all probably know most of what I'm about to tell you. This presentation, sort of a dog and pony show, is something that I've been tasked with marching around to all of the boards and commissions within the Division of Regulatory Boards for a couple of reasons. One, most folks haven't heard about this in a more formal, structured way for probably 5 or 6 years, and we've had a lot of new commissioners and board members come on in that time, and they've never had any formal introduction to the material. And so we want to catch everybody up and make sure everybody's on the same page. And if there are any misconceptions or cobwebs that have kind of crept up over time, we want to go ahead and clear those away and get everybody moving forward together. All right. So we'll talk about open records briefly. And really we're talking there about Freedom of Information Act requests, anything you all keep records of, whether it's your minutes, your agendas, anything that is liable, the recordings of these meetings, anything that's liable to be requested or discovered by some other person, some member of the public later, that's open records. And if you ask, okay, well, what's included? What is liable to be requested? And it's pretty much all documents, papers, letters, maps, books, photographs, microfilms, electronic data processing, files, and output, films, sound recordings, and if that doesn't give you a clue, all other material, regardless of physical form or characteristics, anything in connection with the transaction of official business.
Question, would the financial information about the companies that we regulate, is that also a public record?
Mr. Chairman, it is not. That is specifically exempted by the Tennessee Collection Service Act. The Open Records and Open Meetings Act, those are statutes of broad general application. However, somewhere in the morass of words and language in those statutes, there will be something that says notwithstanding other laws to the contrary or subject to other laws, rules, privileges, or something that otherwise exempts it from disclosure. And in the case of this board, the financial information, as we remember from the Rialto proceedings a couple of meetings ago, that was really the only thing that that was exempted from disclosure, because the Tennessee Collection Service Act at 622119 says so.
So when I say everything, it's everything related to your business as a commission. And that's pretty much it as far as open records go. As I mentioned, on a day-to-day basis, dealing with those records requests processing them, deciding whether or not to give over the records is going to be handled either by Ms. Whaley and her staff, and maybe working in conjunction with the Open Records Council. There's a whole office of Open Records Council, excuse me, that deals with exactly those things. For the purposes, though, of our time together this morning, we're going to talk mostly about the Public Meetings Act, what it is, what a meeting is, and then what a meeting is not, and that's sort of amorphous in the minds of a lot of people. We'll try to put some fences around that. Once we figure out what a meeting is under the law, we'll try and figure out what is required of you all under that. Broadly, we'll talk about notice, agenda, public presence, and then minutes. We'll find as we move forward, once we figure out what a meeting is, and once we nail down notice, we will have covered about 95% of everything that you all are responsible for on a day-to-day basis or a meeting-to-meeting basis. And then briefly, we'll touch on penalties. And really, there's only one, nullity, which is a fancy legal term for the idea that if you all either mistakenly or on purpose, God forbid, violate the Sunshine Law, then we're going to, or a court, if you get sued, is going to rewind the clock to the time when that bad act occurred and pretend as though it never happened. And that doesn't sound like much. You say, okay, well, just, you know, that evaporates that one thing we did. But we'll see as we go on that that can have some fairly disastrous consequences as it moves forward again through time. I have recently graduated from law school. Please pray for me. That having been said, I despise legalese, and so we'll try and get through it in the plainest English we can. I do need to quote some laws for you, though, and we'll touch on just one or two court cases as we move forward. The General Assembly hereby declares it to be the policy of the state that the formation of public policy and decisions is public business and shall not be conducted in secret. Public policy is going to be your rules, your regulations, anything you do to adopt a new rule or reg, delete an old one, or modify an existing one. All of that's going to be under the label of public policy. And then pretty much everything else you do, discipline against a license, issuance or revocation of a license, issuance of civil penalties, consent orders, any of that stuff is going to be under the and decisions portion of it. This is the free speech portion clause of the Tennessee State Constitution. And it says, look, you can't, we're not going to limit your ability to speak freely. The way to read those two things together, this law code and your free speech rights as a citizen of the state, is to say, look, by taking on this position, by volunteering to serve or be appointed to serve, you're not giving up your right to free speech as a citizen of the great state of Tennessee. What we are saying is that anything you do say, or anything that you do in your capacity as a commissioner, has to be on the record and has to be subject to the public notice requirements we'll talk about later. The act is remedial in nature, which is a fancy way of saying we can't fix something that goes wrong until after it goes wrong. We can't fix it before the fact, and therefore we're going to construe it very broadly, excuse me, to protect the public at every stage. And we see this for the first time here. We will see it very consistently, that every single time, it is one of the most clear areas of law that we have in terms of how the legislature speaks and how the courts speak, really with one voice about this. Every time you hear a court or the legislature talking about this, they're going to do so in this very broad, very expansive language with the stated intent to leave no loopholes at all. All meetings, again, this very broad language, of any governing body are declared to be public meetings, open to the public at all times, except as provided by the Constitution. That exception is one very narrow exception called the executive sessions exception, which you may be somewhat familiar with, and we'll talk about that in a little bit more detail in a few moments. Excuse me. Applies to all department regulatory boards and commissions, meaning it applies to y'all. Governing body means the members of any public body which has 2 or more members and the authority to make decisions or recommendations. Well, if we say the law applies to governing bodies, but a governing body is really just a kind of public body, haven't we just moved the problem back one step? Then the question is, well, what's a public body? Excuse me. And the fine print down here says that the legislature intended to include any commission, board, committee, agency, authority, or any other body by whatever other name. Again, that very broad, inclusive language. This is to solve a problem that we had a few years ago in the state where some boards and commissions said, well, as long as we take the up or down vote in a plenary session with everybody present on the record under the gavel, we're fine. And then we can take our committee and subcommittee meetings and do those behind closed doors. No, everything is intended to be picked up here. All your committees, subcommittees, education committees, any of that kind of stuff. So then let's talk about what a meeting is. A meeting means the convening of a governing body of a public body, so again, your committees and subcommittees as well, for which a quorum is required in order to make a decision or deliberate towards a decision. We'll talk as we go on, folks, about what I have started to refer to as the 3 Ds. Debate, deliberate, and decide. Anytime you are debating, deliberating, and deciding, it's got to be on the record. And that's sort of the nifty rule of thumb about it. There is a 4th D, discuss. And that kind of gets into some muddy waters. Excuse me. What's not a meeting? A meeting is not any inspection of an on-site program. I don't know if that really applies here in the Collection Service Board. Some other boards or commissions, for example, the Motor Vehicle Commission that regulates car dealers, they will send out staff investigators on a regular basis to make sure that the car dealers are advertising the cars properly and things like that. Well, if you send an investigator or an inspector out, the law is going to say that's not a meeting of the board. And you can see if they did, that would get unwieldy very quickly. Excuse me. What's not a meeting? A meeting does not include a chance meeting of 2 or more members of a public body. So if y'all happen to bump shoulders in the Kroger or the Piggly Wiggly, that's not a meeting. However, no such chance meetings or informal assemblages can be used to, again, there's those Ds, decide or deliberate public business in the circumvention of the spirit of the act. I mentioned that I was going to talk about just 1 or 2 law cases. This one down here, Aiken, there's a small town in Tennessee, Kingston Springs, or it was small at the time, and they decided that they wanted to annex some unincorporated county land that surrounded. And what happened was they took the up or down vote, yes, we're going to annex, in a full meeting like this one, on the record, properly noticed, under the gavel, everything was cool, except for the fact that they decided exactly which parcels and plots of land they were going to annex behind closed doors in those committee meetings. And so they got sued because these people suddenly found themselves part of the city of Kingston Springs or the town of Kingston Springs, and they didn't want to be. And so they sued, excuse me. And the court said eventually, well, because they took the up or down, yes or no vote on whether or not to annex in a properly noticed meeting that everybody could have attended, then technically they didn't violate the Sunshine Law. Or if they did violate it, they cured their violation by doing that final vote in public in a properly noticed meeting. And you think, okay, well then what's the problem? The governmental body won. What I would like to suggest to you, and why I wanted to make the point or take some time with it real quick, is that you'll notice this case went all the way up to the Tennessee Court of Appeals, which means they did that entire dance at least 2 or 3 times. And so if you start to think about the massive black hole of time and expense and effort on the part of your staff, on the part of the commissioners, or in those cases the town councilmen and aldermen, had to be subpoenaed, give deposition, give testimony over and over. It can really bring the business of the town, in this case, or your commission, to a grinding halt. And so what I would like to suggest to you, and I'll reinforce the point later, is that if you get sued, you've already lost. And so we want to, and part of the reason that I'm here this morning is to try and remind all of us to be as scrupulous as possible so that we stay out of that hot water in the first place. This is an excerpt from an opinion of the Tennessee Attorney General. It says 2 or more members of the public body may share a meal together in which public business is conducted, but the discussion should not constitute deliberations. I mentioned our 3 bad Ds. Anytime you deliberate, debate, or decide, the courts are going to say that's public business. It has to be on the record under the gavel in a properly noticed public meeting. But now we're saying, well, we can have discussion, and that doesn't count. Folks, if you can accurately guess as to whether a judge is going to say 4 or 5 or 6 months from now whether what y'all were doing over lunch was only discussion or actually rose to the level of deliberation, you're much smarter than me, which is probably the case anyway, but for different reasons. You see what I'm saying? It is a very fine line there, that razor's edge between discussion and deliberations, and really is not a place where we want to go or spend a lot of time. What else is not a meeting? Lunch breaks, restroom breaks, smoke breaks. If you have a recess for lunch, if you have a multi-day meeting for any reason, and recess at night at about 4:30 or 5 o'clock at night, that overnight time until you reconvene the next morning is not a meeting. But because they're not defined as meetings, then of course we're forbidden from discussing or deliberating board business in the interim. This paragraph of the law picks up all of your regular meetings, also all of your special meetings. I don't know if you all have occasion to have emergency meetings. Some boards or commissions do, where they say, you know, we've got a licensee out there who is a bad actor, and such a grievously bad actor that we cannot wait until the next regularly scheduled. Find that even those emergency meetings have to be scheduled out 2 and 3 weeks. Provide adequate public notice, and so we're going to pick those emergency meetings up as well. The only exception, again, is that executive session. Excuse me. Let's talk about executive sessions. Executive sessions occur when 3 things happen, and it has to be all of those 3 things. When one or more of you, so it can just be one, meets with your attorney, Mr. Whitaker, and you are under suit or you're under threat of suit. Somebody has said, I don't like the decision you've made, I'm going to sue you. And you ask your attorney questions related to that suit or to that potential suit. This is designed, folks, to maintain your attorney-client privilege with your board counsel, Mr. Whitaker. Okay. But it cannot be used, and a lot of boards and commissions, unfortunately, have tried it, and it leads to very strongly worded decisions coming out of the court. Those executive sessions cannot be used as a backdoor to deliberate board business or commission business behind closed doors. Excuse me. So if you walk out into the hallway on a lunch break and some licensee says, I really don't care going to sue you, that would be a perfect time to get into an executive session with Mr. Whitaker. Ask him about that. Say, okay, well, we've had this threat of a lawsuit. Now, what are the consequences if we do X? What are the legal consequences likely to be if we do Y? And he's very well equipped and trained to give you his sound legal counsel about all of that, right? Fine. But if we're sitting here and you're asking him questions, and he answers your questions, and then you say, okay, well, based on what Mr. Whitaker has just told us, I think we should do X. Stop. Now we're getting into debate. You're offering your opinion as to how you might vote should the matter come up for a vote, and that's when we need to step back, get back into the committee room, get back on the record and under the gavel and then go forward from there. And by the way, part of Mr. Whitaker's job is to stop you from doing that. If you go into an executive session with him and then you get into that where it gets dangerously close to that area of debate or deliberation about commission business, if you don't stop yourselves from doing that, he's supposed to stop you and say, wait, we need to get back on the record. There you go. Can't deliberate about any specific matter before you or potentially before you. That picks up all of the, well, Mr. Whitaker, hypothetically, if we had such and such happen to us, what if we did X? That's, excuse me, that's going to be covered as well. So how far does it go? This, and it's probably mislabeled up there, this is not really part of the executive session, but you say, well, this public meetings thing, if everything has to be out in the open, and if every little scrap of everything we do has to be on the record, I've had the question come up a lot, this is just going to slow us down. It's going to destroy our efficiency and our ability to do our job, the mandate for which the governor put us up here. How far does this go? Here we have a case where the Maury County Civil Service Commission was conducting first-level interviews. And after these interviews, the commission would get behind their closed doors, and they would say, okay, what did you think about this candidate? What did you think about that candidate? And the people that passed that first interview, that first screen, would go on to the vetted list, and the Maury County Sheriff's Department would hire deputies and other staff from that vetted list of people. You've got the Tennessee Attorney General here saying that those meetings to decide who passes that first interview, because the results of those meetings are so important to the public, there's going to be, who's pulling them over on the side of the road later as sheriffs. That's probably covered under the Open Meetings Act. Not to put too fine a point on it, folks, but if job interviews before a civil service commission are probably covered under the Open Meetings Act, that gives you a good idea that pretty much everything you do also is. Let's talk about electronic communications for a minute. If one of you emails Chairman Howard and says, here's a news article related to our profession, I think we ought to discuss it at the next meeting, the content of that communication would be fine. If you went a little bit further and said, I found this news article and I think it's important and I want it put on the agenda for formal discussion, that's fine. But if you say, I saw this news item in the Tennessean about one of our licensees and he's a bad actor based on this and I think we should consider disciplining against that person's license or that firm's license, again, that gets into the area of debate or deliberation, and since you're doing it outside of the venue of a public meeting, it would be forbidden. If one of you communicates with Mr. Whitaker and says, I have a question about the legal consequences of something the commission has done, that's fine. If you have questions about something that you have done in your individual capacity as a commissioner, if you say go speak to a trade group or go speak to a bunch of high school kids about the glamour of your profession, but you didn't have the blessing of the whole commission to do so, and then you want to talk to Mr. Whitaker about, hey, am I in trouble for this, or what do I need to do to fix it, that's appropriate. But if you get picked up for your 19th DUI in 15 days, he probably can't help you and you would need to go get your own attorney. This sort of inter-commissioner crosstalk is where we start seeing a lot of trouble then. And we talked about that chance meeting. If one of you runs into each other, or one of you runs into another one at the grocery store or at church on Sunday, that's a chance meeting. But if one of you takes the deliberate step of picking up the phone and calling another one or tapping out that email, the courts are going to say that's not a chance meeting. It was a deliberate act on the part of at least one person to make contact with another commissioner, and so you're not going to get that exemption, and you're going to be liable for a violation of the Sunshine Law. And so I talked before about the idea that, look, there are some communications, the content of which is perfectly innocent. I saw a news item related to our profession. I saw your little girl in the school play the other week. Wasn't she cute? We understand as professionals that the content of those communications are perfectly innocent. But that obviously is not what the news media or whoever else is going to see upon making this public records request. What they're going to see first is that, if they discover it, is that you've got one commissioner talking to another commissioner off the record. And it raises this huge red flag and brings up the appearance of impropriety. And so for safety's sake, those discussions ought to be avoided. Talk about electronic attendance for a moment. What if one or more of you can't be here in person? If one of you can't be here in person, but you can still make a quorum with the remainder, fine, you just move forward. And if that other person wants to be telephoned in and speak over the PA system here in the committee room, that's fine as well. Excuse me. But at that point, any absent members, any physically absent members who are being included in the proceedings telephonically, that's going to put us back into a position where we have to do all of our votes as roll call votes. When all of you are physically present, if there happens to be a member of the public in the room, they can see how you're voting. If one of you is not present, we're going to fall back on that roll call vote and do away with our all in favor say aye type of votes. We'll do everything by name so that, again, the public can see who is voting how. Excuse me. What if there are not enough of you to make a quorum in person? But you can get to a quorum if you include some other commissioners telephonically. What you can then do is adopt what's called a statement of necessity, simply a verbal statement by the chair saying, look, we understand that by the rules we have to have a quorum to proceed, and we can't get there by the number of people that are physically present, and we understand that. However, we have a need, we have a necessity, we have a mandate from the public and from the governor who appointed us to do this business in a timely manner. And so because of this necessity and because we can get the requisite number of people here by telephoning them in, we're going to go ahead and do that. It's a simple verbal statement made by the chair, and then it's in the record, and then anybody coming back and checking after you can say, okay, there was a good reason for this. And then the meeting goes forward as normal. So blowing back up to kind of the 10,000-foot bird's eye view, again, we see the act is to be construed most favorably to the public. It is all-encompassing. It applies to every meeting of a governing body, except where the statute on its face excludes. That exclusion has to do with the public fisc. Doesn't apply to you all or really any of the boards and commissions in the Division of Regulatory Boards. It has to do with those bodies that are authorized to commit the state treasury to things. Let me take this moment to talk about this Shelby County Board of Commissioners case. This is the other case that I wanted to talk to you about before. I mentioned nullity as the penalty for a violation of the Sunshine Law. And this is a terribly sad case. Shelby County, of course, is not a small place. The Shelby County Commission has 11 members, and one of its long-serving members had passed in office. Their rules, it is to the rest of the commission then to take a vote and appoint a replacement for the remainder of that person's term, and then the next public election. That gentleman had served in a strongly minority part of the county, and it was felt that it was very important morally to have another person from that community represented in that gentleman's seat. So of the remaining 10 commissioners, 3 of them got together and started taking a series of phone calls between and amongst themselves about who ought to be nominated. They came up with a short list, and they eventually narrowed it down to one candidate that they all agreed upon, and they telephoned the fella, and they said, if appointed, would you serve? And he said, I'd be honored to. And this is all in the facts of the case. And so at the next full commission meeting of the Shelby County Commission, the chair sits there and opens the meeting and starts the meeting by saying, we'd like to offer our condolences to Commissioner so-and-so's family and thank him for his years of service. Now it's our responsibility to appoint his replacement for the remainder of his term. Are there any nominations? One name was nominated. Is there any discussion? There was no discussion. All in favor say aye. Unanimous vote to approve him. The gentleman's in the audience, in the gallery, comes up, gets sworn in, takes his seat, and begins to serve. Now, we can obviously and immediately say to ourselves, this doesn't pass the smell test, right? Something doesn't smell right. And sure enough, a member of the public sitting in the gallery said, this doesn't smell right, and sued. There was only one nomination, only one candidate, no discussion about who the best person for the job would be. Come on. And so, again, we'll see that this went all the way up to the Tennessee Court of Appeals, one step shy of the state Supreme Court. And so, again, they did that whole dance 2 or 3 or 4 different times, depending on how they went through it. The end result of which was nullity. It was a clear textbook violation of the Sunshine Law. And so the court went back and said, as of the moment he was appointed, or all that discussion took place, that was the violation. And so that act to appoint him to the seat is nullified. Okay, no problem. The guy steps down, he goes home, we all move on with our lives, right? Wrong. In fact, what happens is now every committee he chaired or subcommittee in which he cast the deciding vote was tossed out with him. Because if he wasn't there, because it was as though he wasn't there, it was as though he hadn't been appointed because his appointment was the violative act, now it's going to all flow downhill. And everything in which he was involved is going to be under a cloud, and most of it is going to be reversed. And so with the best of intentions, we have this gross violation. As I said, Shelby County, folks, is not a small place. And so what we wind up with is the entire county coming to a grinding halt for a period of about 6 or 8 months, and the public budget for that fiscal year being destroyed as they had to stop, rewind, and go through and undo or take a second look at every single vote that guy cast. And so we can see that nullity, while one simple little word, really is going to have vast consequences in the face of a violation. All right, so that was pretty heavy. Let me lighten up on you for a little bit. The public has a right to attend and observe your meetings, but not the right to participate. You are not required to let anybody speak. There's a recognition in the law that you all have a job to do. You have an agenda, you need to stick to it, you've got to get your business done in a timely manner, as timely as reasonable. They let the public speak if that includes a group of licensees that happens to be in the room and they're particularly concerned about some vote that's on your agenda today. You can do that. You can also place reasonable limits on it. Chairman Howard can say, look, we've got a busy agenda, but we recognize that we want to have people speak, and so we're going to limit it to 30 minutes. And each individual speaker can only comment for, as long as you treat everybody the same, you're fine. So you may let people speak, but you are by no means required to. I mentioned earlier that once we deal with what a meeting is and what it's not, what's required from you under a meeting, and then once we deal with notice, we will have covered almost everything that you all are responsible for, at least in a broad view. So there's a 3-pronged test for adequate public notice: contents, timing, and location. The contents of the notice have to reasonably describe the purpose of the meeting or the proposed action to be taken. By the way, reasonably describe is the key phrase. A question comes up frequently, well, not that frequently, but there are those who, sitting on boards or commissions, believe that they are chained with heavy chains to their agenda, and that it is like Charlton Heston standing up on the mountain with the paper mache tablets, and it's carved in stone, and you cannot deviate 1 iota from that agenda. We'll see, first of all, at the bottom of every agenda is a line item that says new business. And nobody knows what that is going in by definition. And so that ought to give us a clue that, that the agenda is a guide, but it is not something to which we are indelibly bound. Excuse me. Now, neither does that mean you can completely ignore your agenda. The whole point, again, is your relationship to the public, so that if there is an agenda item about which a member of the public or a licensee is especially concerned, they can have a reasonable expectation by reading the agenda that if they show up on that day, that item of interest to them is going to be discussed at some point. Timing of the notice. If you give the greatest, most accurate notice in the world 5 minutes before the commencement of the meeting, that's obviously going to be insufficient. The rule of thumb that the courts have come up with in a series of decisions down through the years is about 7 to 10 days. Typically, if you will post your adequate public notice 7 to 10 days in advance of the meeting, you'll be covered. As a matter of fact, if you were to check your commission's website, you will see that Director Whaley has already published all of your meetings for the remainder of the year. And so we are well covered on that point. Excuse me. Finally, location. If you give the best meeting and the best agenda in the world a year ahead of time, and the only place you post it is in the basement next to the boiler room, what good does that do? So it has to be posted in a location where if the member of the community could become aware of it. We talk about newspaper there briefly. We mention it. Newspaper is not really used at the state level anymore. You will see the phrase, or you may have seen the phrase, a newspaper publication. Those are interchangeable terms. Only used these days at the municipal or county level to publish things like tax sales, seizures of property, auctions of seized property, things like that, so that the county commission can't say, can't auction off some seized property and say, well, we published it in the Costco flyer. Is that not good enough? No, it has to be a newspaper of general publication or of wide circulation. As a matter of fact, we do everything here at the state level by internet these days because that has the broadest conceivable publication. And then bill posting is simply stapling up flyers everywhere. They used to do it that way. And even today, although it's not really officially a part of our notice, you'll see that as you walk in the front doors of the building, there is a bill posted that says Collection Service Commission meeting this way, so that nobody can wander around the building and all right. This is, again, just an opinion of the Tennessee Attorney General that talks about the AG's opinion. This is one of his opinion letters on how to publish adequate public notice. And you'll see that we publish it on your commission's website, also on the Department of Commerce and Insurance's website. And in fact, I'm to understand that there is a sort of an email blast system that members of the public can sign up for that will shoot an email out to them automatically and let them know when something's coming up that they're interested in. Excuse me, it's kind of neat. All the facts and circumstances analysis, meaning you have to do all three. You can't publish the notice 3 years ahead of time and say, well, we gave such consideration to the timing of it, surely that covers a deficiency in the contents of it. No, it's got to be all three. I talked at some length then as we wrap up here about the legal effects, nullity. And nullity is in fact more than what it might sound like on its face. There's a practical impact too. I talked about the idea that, if you get sued, you've already lost. Just because of the massive amount of time and staff costs that would be assessed in just getting you all of that and defending you from a lawsuit. There's something else though too, and this is not that little case that I cite down there at the bottom, Rebecca Little versus the City of Chattanooga. That's not an open meetings case, it's a public records case. The City of Chattanooga improperly denied her open records request. And then she went back and asked for attorney's fees. What my boss refers to as the American rule. The American rule is that, generally speaking, win, lose, or draw, everybody pays their own attorneys, everybody pays their own court costs. That's more or less how we do it here. This case says just the opposite. She sued asking for some trial court denied it to her and said, no, the American rule applies, everybody pays for their own. Said, look, but for their bad act, I would never have had to incur these legal costs in the first place. And so they should have to pay my attorneys. Back down to make the lower court make the city pay her attorney's fees. And the lower court then said, well, okay, but $70,000 is excessive. The attorney was just racking up the bill because they knew they were coming after a government agency, right? So, half that. She appealed again, and the Court of Appeals again said, no, not some of the attorney's fees, not a deposit, not a payment, not a structure, the whole thing. She incurred those costs, and that's what the city has to pay. And so if you're counting, that's 5 times in court. So all of the court costs of that, added on to all of the court costs, the $70,000 that she initially had to incur because of the city's bad act, and so on and so on. And so, and that, by the way, that case is hot off the presses. That was Valentine's Day of this year that case came down. Now we've got this precedent in Tennessee that tells us that if a public body violates the sunshine laws and gets sued, there's a very real possibility very quickly paralyze your ability to do work for the next year in terms of operating budget. So in a nutshell then, it is designed to make sure that all regulatory board and commission business is conducted in a way that's accessible to the public. It absolutely applies to the members, excuse me, of the Collection Service Commission, both plenary and individual. That only exception, again, is going to be that executive session, your top opportunity to ask your attorney, Mr. Whitaker, about questions related to any actual or potential lawsuit. But you cannot deliberate or decide or debate public business in those executive sessions. And then finally, again, for every meeting, you have to give adequate public notice. Folks, that concludes the presentation formally. If there are any questions or comments or complaints, I'd be happy to entertain them. Very much for your time.
Thank you.
Chairman, thank you.
Thank you, Damon.
Along to administrative report.
Yes. On tab 3, you will find your complaint comparison report. And I'm happy to report that we're doing very well with 94.1% of our complaints being closed. The division's performance measure is set at 75%.
Good job.
If there are no questions on tab 3, we'll move on to tab 4, which I've provided you with the revenues and expenses through March 31st for fiscal year 2014.
And
Questions or concerns? If not, we can move on to tab
Well,
5. Okay.
I have a question. The dollars we collect for our consent orders or fines, is that listed anywhere where we can see it?
Yes, sir. It is actually on the, if you move past where it says tab 4, the first page, regulatory boards, then it has 2 line items. The second line item is actually your complaint collections through March 31st. And these, I'm providing you with I know this may be a little different from what you saw in previous months. This is the most recently published from our fiscal office.
Okay, so year-to-date, we've collected $7,500 in fines.
Yes, sir.
Okay.
And that is pure collection. That does not take into account anything you have out
Right.
that's on a consent order.
Okay.
How do you follow up on the consent orders, Chris?
Essentially, when we send out a consent order, I draft it, do a cover letter with it, and we'll typically include some sort of time frame for acceptance or not acceptance. I try to phrase it very specifically and say, if we do not receive a response from you by such and such date, then the consent order offer or the offer as set forth in the consent order may be withdrawn without further notice, and this matter is scheduled for a formal hearing. Basically, what I'm trying to do is to prompt the respondent to action, to get them to call me and discuss it if they have any questions, or if they don't, just provide them instructions on, how to sign the paperwork and where to send a check and everything else. When that period elapses, whether it's 30 or 45 days, it's a two-pronged approach. Number one, we will switch it over to the status in our reg board system, RBS, to say legal formal charges authorized, because if you'll note, the way I write up the descriptions on the legal report says, in the case of licensees, formal hearing with authorization for license revocation. That way it includes the whole potential range of penalties allowed by statute and rule in a potential formal hearing, then with authority to settle by consent order on these terms. And so that's why we would go in the RBS system to formal charges authorized, and then I will follow up either as the time gets closer, or if I happen to notice that it has elapsed, just recently, if I have a number to call someone in authority who could potentially sign and accept on behalf of the respondent, I'll just call them or send them an email and say, hey, look, the board sent you this settlement offer via consent order. The time period for you to accept it is either about to pass or has now passed. This is your kind of last chance, last call. If you would like to accept it, please contact me and tell me how you intend to do so and when. Otherwise, we'll move this on to litigation and get it set and move it forward from there.
Are there any consent orders in that process of moving on to a formal hearing?
Prior to this meeting, there were only 2 complaints that have consent orders out right now. Neither of them, to my knowledge, have been accepted. I do believe one respondent signed for theirs. The other one may have come back, or just may not have picked up the certified mail, but may have gotten the first-class mail copy. But in either case, neither of them have been set for a formal hearing yet, and the litigation counsel for this program is Robin Ryan, and if there is to be a formal hearing, then once it's determined that the settlement as put forth by the board will not happen for any reason, it will be, once it goes to formal charges authorized, I will transfer the file over to Ms. Ryan, and she will begin working on it as necessary to prepare it for a formal.
Are there any other questions?
Request for determine license requirement based on business practices, tab 5.
Yes, sir. This was a letter we received, and it does at length lay out their process, and they're asking if they would, based on their practices, be required to be licensed.
If you would like my summary of that, I can
Please.
go ahead with that. If you would prefer to read it all, you're welcome to.
No.
Okay. It appears that this is an entity that is under the umbrella of a larger parent company, and as I read their very detailed summary, the things that stick out are that they appear to be collecting what are in their minds not yet delinquent debts. And I really think that that's probably the determining factor that the board would need to consider when advising these folks whether they need a license or not. If you look on page 3 of their letter, the first full paragraph, and I'll just read very briefly from that paragraph, and it says, additionally, when we commence servicing of accounts, such accounts are not delinquent since we service them from origination. And reading that in conjunction with the rest of their letter, it appears that they are simply attempting to outsource what would otherwise be first-party normal account maintenance for non-delinquent accounts so that they don't have to do it. And then, they say the conundrum for us is in reading whether delinquent is at the time servicing starts or when contact with the customer is made. I think what could be determinative there, moving back to page 2, the last full paragraph, it's, I would say the last sentence of that paragraph. As described in the narrative, our contact with the customer is in the nature of an inquiry rather than a, quote, collection activity. And here's the key language. Once it becomes apparent that this company can no longer assist in the resolution of a dispute or believes that the customer does not have the ability to pay an account, this entity will cease servicing the account, notify the client of same, and then it is up to the client to determine their next action. I think when you read all of that together, there is a fair argument to be made that they are a non-delinquent account servicing company, and that when the accounts become ripe for, as they describe collection practices, and as this board has generally contemplated them, dunning letters, collection calls for accounts that are, really some level of time past due, pursuant to the contract terms of that various debt. And then I think the last factor to look at, they have provided a services agreement between themselves and affiliates, and without slogging through all of the material on pages 4 and 5, the factor that sticks out also is that this entity does not receive money on behalf of the client. Even checks that are paid appear to be done electronically and then done all by computer and go to the ultimate client who is supposed to receive the money. And if there are funds that are to be sent in, a lockbox P.O. box address is provided to which this entity has no access. So that's my broad overview. And Mr. Harb?
I don't know why that one is acting up today. I'm so very
Oh, it's all
sorry.
right.
Someone may have, hitting the speaker may fix it now. Somebody may have turned it
Does
off.
it appear that they are collecting in their name or the customer's name? Or the It looks like they're calling on behalf of the, under the name of themselves as opposed to using their own name. If they're not using their own name to collect, they're not a third-party collector anyway. See that anywhere?
No, and I didn't see anything that would lead me to believe that they are doing so.
Yeah, if they're using the name of the originator to collect under, then they're not a third-party collector, in my simple understanding.
Right. As
I
long as
agree.
they're- As long as they're collecting in the name of the original creditor, they don't need a license.
Then they are a bookkeeping service, as they define themselves. In your response, you might want to suggest that as long as they don't use a name that they don't need a Tennessee license for what they're doing.
So then, would it be the board's preference to obtain clarification on that point from this entity? And if the answer is that when they call in the name of the client. The board would be inclined to approve their request, or to, I guess, agree with their position that they don't need a license. Whereas if they are saying that, that they do call in their own name, then it could be that it may need to come back before the board for additional discussion.
That's exactly right.
Okay, so,
I don't even think they need a license for what they're doing.
Not if that's what they're doing,
But
but it is confusing. I got confused trying to read it.
Yeah.
But I feel like that the original creditor is the one that is sending the letters and making the phone calls. Once it becomes delinquent, then they give it back to the factoring house, I assume, and that factor house turns it over to an agency or an attorney for collection.
That's the way I read it.
I mean, I think the key sentence here on which I guess Mr. Harb and the board as a whole are seeking clarification on is on page 2. The services provided in RMS, which is their acronym for Receivable Management Services, do not, bold underline, include demanding payment, dunning activities, and/or action to enforce the collection of debts, including commencing of litigation. So, I guess, you know, that small piece that is needed to be fleshed out. It's like, okay, well, you know, if you're calling the customers, you know, how are you calling them? I mean, what are you saying? I mean, if you're saying, you know, this is Representative Smith calling on behalf of original client who would be responsible for all this stuff they don't do, and then they do this other stuff, probably true bookkeeping, no license required. However, if they're saying this is Representative Smith calling on behalf of the people who sent this letter, maybe a different calculus.
The letter said that as long as you're doing it based on this fact, on the fact that you're doing it in your name, then you're okay. If in fact that you do use another name to attempt to collect, then you are required to have a license.
Okay, I will reach out to Mr. Franklin here and try to ascertain that, and then whatever the response is, have him put it in writing. And when I receive that, if it's the former, then we'll send him something back saying, under this set of facts, no license required. If it's the latter, then we'll need a license.
For me, what does it cost to have a collection license in Tennessee now?
$600 initial application fee plus surety bond coverage at renewal every 2 years, another $150 plus your surety bond, and then whatever your cost of doing business.
I know this company, and for a company this big, not to go ahead and spend $700 and get a license is just, I don't know why they don't do it anyway.
Well, I'm sure they're paying this very fancy lawyer more than that
More
to
than
even-
that,
to
more than a
even send
lawyer's
this letter.
license would have cost, yeah.
But hey, that's their call.
That's right.
If they're a first-party collector, they don't need a license. And that's what, everything they do sounds like a first-party collector, not a keeping service, let me say, as opposed to a collector.
Discussion of attorney exemption under Tennessee Collection Service Act. I think have we already had that discussion?
That already?
Okay. Administrative report. Are we back on that now? Review of revised financial statement application, tab 6.
Okay, Chairman Howard, this is the revised draft of the financial statement form that agencies submit as part of the application. It is substantially narrowed and based largely on Mr. Harb's recommendations. It seems to definitely, in appearance, a little bit cleaner and less cluttered, while also maintaining and getting the main information required, and also hopefully not causing any problems for the CPA who will have to bless the statement. Looking on page 2 of the applicant's affidavit, I did want to bring this to Mr. Harb's attention so that he wouldn't have any heartburn about it. Notice that the signature is required for the manager or owner's name. We're on the lines that say CPA or PA name, license number, state of licensure. We're not requiring the CPA to sign that form or anything like that. It's just the applicant, the authorized person at the applicant agency providing the professional information of the CPA who did the work. The actual, I'm the CPA and I hereby bless this statement, appears only on the actual statement itself that is attached to this.
Page 2, attach a financial statement prepared and signed by a certified public accountant with their license number. Yes, makes that clear to me.
Yeah.
The other is just you're duplicating the information so you can match them up. So yeah, as long as the CPA doesn't have to sign the form, then we're fine. We're not putting the CPAs in a lurch. They're only signing their form with their cover. We didn't say anything about the CPA's report, but that's okay. They're going to attach a report to the financial statements, and that's how they transmit. So I think
I think it's fine.
the only thing you might, under total assets,
Okay.
you put total assets from statement attached. You might say total liabilities from statement attached. It's pretty obvious that it should be from the financial, to match the financial statement attached, but talking the lowest common denominator here.
Okay,
So
so,
under the liabilities section, have a
Yeah.
accounts payable, other liabilities, total liabilities? and
Well,
then
you know, what's there is fine. Accounts payable, other liabilities, total equity, and then total liabilities and equity. But that total liabilities and equity number needs to be just like the total assets. Notice how you said from statement attached. And total assets and total liabilities need to equal. And they should both line up with the statement attached, and the form should add up.
that
you know.
seems pretty simple.
That gets it as simple as you can get it.
But we will add those 3 words onto that very last bolded total line.
The other thing for just pure simplicity, and again, the lowest common denominator reader, is you might want to take that same statement and put it at the very top. It says attach a financial statement. It's kind of, as opposed to having it where it is, which is at the end of the statement, it's to me, it ought to go at the top and maybe even on the second page. That's really the essence of what we're getting, is the attached financial, and then you could go on to say, fill in the rest of this form and sign it based on the attached statement. Where that's located is not a direction. Our forms don't have directions or spec for each box. That would help make it a direction.
Okay, well, we can
Oversimplifying, I know.
we can shift that from under the total calculations and liabilities and equity up top, right underneath the financial statement caption. So the very first thing that they're seeing is that before they take off and get going, and that should eliminate any confusion.
You might even want to add, I know this is a little simplistic, attach a financial statement and complete this form. Attaching the financial statement does not preclude you from completing this form. As I can assure you, people
there'll be-
will assume that all I have to do is attach a statement. Attach this statement and complete this form with the items required, because, and now I'm getting really picky, accounts payable clients, most people call it due to clients. They don't really look at it as an account payable. It's a Bailey item, and so it's almost due to clients. Accounts payable clients. What do you all, do any of you ever fill your?
I have when I had an agency, I had a line item due to clients.
Yeah. Almost everybody uses the due to clients, because that's what we're looking for.
to match up with
Yeah.
the trust account.
That's what everybody that does statements should be. If they're not aware enough to know that due to clients, it's got to be less than cash in trust license. So I would call it due to clients. Thank you. This is really, really good.
Hey, thank you. Legislative update.
Before we
Sorry.
get to that, I'm sorry. Just for the board's information, we will make these cosmetic changes and bring it back just so you can get a look at the final document if you'd like, or I could email them to each board member individually just to look at, and you have to email me back individually, obviously, and let me know what you think, and then if that's,
Y'all don't mind, I won't be at the next meeting. I'd appreciate just doing the email unless.
okay.
Additionally, when you get the next version of this, because this is a form, it has to go through the forms review process. It will have to have a form number, an RDA number, and based on that, they require certain things on the top of it, such as a header with the state seal, so it will, everything may be moved down a little bit with the state seal properly, with the contact information for the board. That is just a standard for all state forms, so.
One thing we want to try to avoid is right now our form takes the liabilities and equities section and your total equities on the next page. If there's anything we can do to compress this so that the form contains both the assets and liabilities, and then that second line, the information contained herein might be on the next page. But it really is confusing. I've seen people look at the form and then it would be valuable to have total liabilities on the same single first page.
Yes, and it should fit. Most of the time, it'll be at the header, and we
Yeah.
can do the state seal on one side and the contact information, so it doesn't move everything down substantially.
Now,
Yes,
it's split on two pages. It's
yes.
really goofy.
Yes, we will ensure, I will make sure when we do that assets and liabilities and equity are all on one page, on the front.
Okay, are we on legislative update?
Yes, sir. On your iPads, you have a tab entitled SB 2133. And this is an engrossed version of Senate Bill 2133. The public chapter has not yet been published. I checked again this morning, as of yesterday, it was transmitted to the governor for his action. We can send you a copy of this if you'd like to review it. Chris and I can answer any questions about it.
I'm having trouble finding it on the iPad. I'm sorry.
On the very top.
I've gotten off.
Oh, okay, I got it. I got it.
Did you get that?
Yeah,
Okay.
I did.
It's on the-
Thank you.
Purpose of this.
I was gonna say, can you just give us a summary of what it is?
What have they done to it?
I will attempt to do so as best I can.
Getting banks out.
Well, there's a little more to it than that, but I'll try and take it piece by piece and do the best I can, and then any questions you have, we'll go from there. This House and Senate bill came through, and it amends several sections of the Collection Service Act, and we'll just take each one individually. The very first amendment, Section 1, is to 622103, the definition of collection service, says does not include any person that engages in or attempts to engage in the collection of notes or guarantees. As I read and understand that, best I can determine, it appears to notes be, for example, securing of real estate, mortgages, things of that nature, and then also personal guarantees where a bank seeks additional guarantees from either an individual or from other businesses above and beyond the creditworthiness or existing assets of the applying person or entity for credit. So if a business or a person, I don't know person, but if a collection agency does nothing but collection of notes and or guarantees, then under this amendment, they would now not be required to have a license. If they do even one thing that falls outside those two specific things, then they're going to have a license notwithstanding that section. if you would like, I can stop at the end of my explanation of each section and take questions as we go, if you would prefer that.
I don't know how much we have to say right now at this, when it's up at the governor's office, but that leaves it wide open for anybody to get in. Notes are also deficiency balances on automobiles. Furniture stores that repossess furniture and have their notes collected. It could be anything.
Almost any purchase debt is a note. That's what you're purchasing. A credit card, the deficiency balance on a credit card, is that a note?
Normally, not so much. I mean,
Not
because
an open account receivable.
no, but it's a little bit different in that, you get the credit card based on your credit worthiness, and you go make the charges, and then you got to pay it back. I mean, there is a credit card contract, but in terms of a note, which is typically secured to something else, some other kind of real property or asset, it's not really there.
Unsecured notes, revolving unsecured notes is just a credit card. You can get a line of credit, unsecured line of credit revolves. Now they issue you a credit card when they give you a line of credit for under $50,000 at a lot of banks, and that's your note. I mean, that's your credit. That's the mechanism for it. So yeah, that's kind of a.
It seems like it just does away with collection services.
Yeah.
That will be for the enterprising attorneys or people who don't wish to be licensed in their esteemed counsel to make that argument. Well, that's, and again, we'll let them decide that another day. I'm just trying to report what's here best I can. I will say that
They not include the board that oversees this in.
What was
Who's behind
the
it?
intent, do you think? Do you think was it a bank thing, or what?
Again, they're allowed to propose legislation, you have lobbyists.
but it
We
really
did-
doesn't explain all that much.
This is the legislation we did in our updates. This is the bill number that we provided. Those things do change from time to.
And sometimes bills come up and, go to committee and then could even make it as far as the full floor, but then die on the vine or don't get a vote or something like that. This was not one of those. So
Okay.
let me move on to section 2. This section's amendment adds, 1, 2, 3, 4, 5, 6 new items to the list of exemptions from the Collection Service Act licensure requirements. Items number 4 through 7, those really, we don't see a whole lot of those anyway, because they're typically regulated much more extensively than would the Collection Service Board, even if they got a license. At the federal level, in the case of banks, and then other, in the Department of Financial Institutions. Sub-item 8, I will admit that I have not looked up this CFR section, this 12 CFR 1026.2. I just hadn't had the opportunity to look it up yet, but I'll be happy to report back on what that exactly means if the board is interested. It says secured by a consensual lien on a dwelling. Sounds an awful lot like a second mortgage or something, but
Guys that were in here before. And number 9 is the winner.
well, number 9 actually codifies the board's clarification statement that, was so much at issue in the Rialto matter and other areas of the state in lawsuits. That once there is a public chapter assigned, that clarification statement can and will be removed from the board's website because it's now codified in statute. So it's not necessary for it to be there any longer.
Alto put this up.
You probably want to call and ask the folks who proposed this legislation and talk to their lobbyists about that. But other than that, I
Made a comment as he left about the attorney comment about legislation. This looks exactly like what they were arguing about.
Well, number 9 says any person that acquires accounts must engage a collection agency to collect them.
Well,
I don't
and
think
to
we-
to the point of discussion earlier about the attorney exemption, which is existing item number A2, if you look down at A9, it says only engages in collection activity through use of a licensed collection agency or attorney authorized to practice law in this state. There is a non-frivolous argument to be made that just clarified it, and so the Attorney General's office may well look at this and say, well, under, the old pre-public chapter of this bill law, we might have thought something different, but maybe now, because of sub 9 here, we think only Tennessee licensed attorneys, but that will be their determination to make. But that was part of the board's now old clarification statement and is now in statute. So there's definitely an argument to be made now that Tennessee attorneys only in the exemption, but we'll see how that goes. Amendment to section number 3. This amends 6220-127, which covers assignments. There's really not just a terribly lot of changes in here. It just specifies what, if there's going to be an assignment, what it has to look like, what it has to say, what it has to contain. The thing that, in my mind, is most conspicuously absent from this list of requirements is that doesn't say that the assignments have to be produced or provided to either this board or arguably even to a court. But again, that's for somebody else to argue in a lawsuit, not me. Then, let's see. Okay, but if you look down to number 5, it says, collection service licensee bringing suit in its own name as an assignee may submit an affidavit of sworn account executed under oath by the assigning party or by a person qualified to execute a sworn account. The licensee shall file a copy of the sworn account with the court for service upon the debtor. So when they go to file the lawsuit, they don't have to provide a copy of the assignment agreement, just
Affidavit.
sworn affidavit from.
They're also saying that a sworn affidavit is not an attempt to collect. Signing an affidavit is not a communication with the debtor in an attempt to collect, by the way this is done. That's a bit of a problem if you use an agency, but you have to sign the affidavit to get the law firm to sue it. Have you communicated with the debtor as a debt purchaser via the affidavit? Then that's gone both ways. This kind of cleans that up. An affidavit is no longer an attempt to collect the debt with this. Maybe.
No, because it looks like what they're saying is the affidavit is swearing to the court that you have the right to collect, not you are not communicating with you agency are not communicating with the debtor. You're swearing to the court that you've got the right to collect, and as such, now your lawyer can file suit on your behalf, and part of what they have to provide to the debtor when they serve them with a copy of the lawsuit is also a copy of the sworn affidavit.
That's the attempt to collect the debt, or at least it's been alleged in some cases that's the attempt.
Right. And in case there were any doubt, section number 4, this is regarding the license requirement. It adds several new subsections. The sub D, nothing in this chapter shall be construed to impair or impede the obligation of any contract, delinquent account, bills or other forms of indebtedness, and so on and so forth. So that is the broader provision saying that the license requirement is not intended to, nor now legally authorized to, get in the middle of any rights that someone may have to be paid under a contract or debt that they own. Moving down to subsection E, I think the summary there is pretty, well, simpler than some of the other things, in that a debtor who has made payment on a debt to an agency that didn't have a license at the time they collected the debt, if that debtor later discovers that and then goes to try and sue and get their money back, they're not going to get their money back now because of the lack of a license. They may have FDCPA or other violations for which they can be compensated in a lawsuit, but they're not getting their money back. Sub-item F, and this is the one probably of most interest to the board in light of recent events and applicants. Any person who is alleged to have violated subsection A, which is the no person shall commence collection action or conduct without a license, number one, may cure the default at any time, even after collection may have started, by filing an application for a license with the board as provided in this chapter, and the board may not use a prior collection effort in violation of this chapter or the assignment chapter that we just mentioned as a basis or consideration for the denial of a license.
That sound like.
We know who that is.
And then sub 2, that person or entity may be subject to sanction by the Collection Service Board, but may not be subject to other civil action or defense based on such alleged violation, which means if they get, they can only speak, I think, for Tennessee. I don't know about the feds, but for Tennessee courts, they're saying that anybody who doesn't have a license, goes to collect, can't be denied a license, can be fined, can get a civil penalty, but can't have their lawsuit tossed out by any state court based solely on unlicensed conduct. And then section 5, gobbledygook.
Retroactive. That section you just read, not 5, but the one before it is at any time. It's retroactive, not just with the
Right.
yeah. So it's
Well, section 5 says remedial in nature, but I think if a statute is intended to and will be applied retroactively, I think it has to either say retroactively period with no, backdating, or retroactive to, January 1 of whatever or whenever.
time.
Well, again, that's an argument for another lawyer on another day to make. So that is
So this is on the governor's desk?
Yes, sir.
This has passed both houses of Tennessee's legislature and is awaiting
It is
signature.
impressive. It is
It's
impressive.
only been a few months. That's impressive.
Actually, yeah, I mean,
Yeah.
during the same session, actually.
I think I would too.
Yes, this is the engrossed version, and the public chapter should be published in a few days, so once I receive the public
Okay.
out to everyone. Oh, you want this one too? Certainly.
I'll
Certainly.
just give him my copy if he wants to take it with him.
There you go.
Sorry
Chris
about
has a
this.
copy.
That's an amazing development.
Mr. Hellman, did you want a copy of this, or do you?
I would
just-
like a copy of it,
Okay,
please.
we will, we'll email.
Just email.
Or just
We'll
email
it out.
Yeah.
Yeah, I think we'd all like copies.
Yeah, I've just now read. Yeah.
Under new business, Susan is going to be leaving our department. This is her last official meeting with us.
Where are you going? Department of
Going
Health.
to the Department of Health, a promotion for her, and I wish
Congratulations.
you all the luck, and you've done an excellent job for us board members, and we appreciate your years of service.
Yeah.
Thank you.
We'll miss you.
Is there any other new business?
Just, with Susan's departure, if you need anything that you would have emailed her for, just email me.
Susan, or Kimberly, will you be sending this on your email, so I'll have your email address?
Yes, sir.
on-
All
okay.
of the information, Susan may email this out, information with this, but I can send you the public chapters.
Okay, that way I'll
And the
have you.
information, so you'll have it.
Yeah, just, I move we adjourn.
Second.
Have we been on the big
Third, fourth.
board all this time?
Oh, my gosh.
Oh, heavenly days.
No.
Oh, darn.
Like watching yourself on a jumbotron.